Okay, first we're going to see what the state of Michigan versus Justin Daniel Ringler, case number 2355496. Mr. Ringler is charged with count 1, robbery armed, count 2, robbery armed, and that is it. Mr. Ringler is defendant number 1. Today's day set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Hey, good morning, Your Honor. David P34972, appearing on behalf of Justin Ringler. No objection to Zoom.
Any discovery issues, Attorney Prince?
No, Your Honor, I have discovery. Thank you.
Okay.
We just would like a preliminary examination date.
We find a date. Let's see here.
Yeah.
I have March 6th as the earliest date. I have a 10 o'clock available.
Would you repeat that date, please, Your Honor?
Sure, March 6th.
March 6th. I may be in trial that day, Judge. Do you have any availability on March 8th?
Yes, you could do 9:30 or 10:30.
10:30, please.
Okay. So March 7th. Did you say March 7th?
March 8th.
March 8th. March 8th at 10:30. Thank you. All right, anything else?
Yes, briefly as to bond.
Okay.
Currently, my client's bond is 10,010% GPS tether, 10 p.m. to 6 a.m. curfew. We're wondering if the court would consider a reduction to 5,010%. My client would live with his aunt at 2095 Euclid in Lincoln Park. He had a job up to the time of his arrest at Little Caesars. As you noticed in the reading of the case, he's not charged with the felony firearm charges.
Anything for the people?
Given the charges, Your Honor, we would ask the bond remain the same.
Okay, on February 13th of this year, the bond was lowered by Judge McConico at a bond redetermination hearing to 10,010%. As you stated, Attorney Cripps, the GPS tether, curfew 10 p.m. to 6 a.m.
Check on Brianna Jones.
I will adjust it, but the curfew is going to have to change.
Brianna. No,
Is your client working? You said he does not have a job, correct?
Was working at Little Caesars Arena doing maintenance work.
Okay. Mr. Ringler, are you seeking that employment once you get out, if you get out, or what?
Yes, Your Honor. Right before I got locked up, I was gonna go to this temp service, and they were gonna give me a job the next day, right by my house. So I was looking forward to do that when I get out.
What are the hours? What were the hours?
I'm not sure. I never went to the meeting, or my I never went up there yet.
This is what I'll do. Instead of curfew 10 a.m. to 6 p.m., I'm going to put you on house arrest until you provide proof of employment to the tethered unit, then I'll allow you to come out the house for work. Okay.
Okay.
So I will adjust it from 10,000. What did you say, Attorney Cripps? 10,000.
I'm asking for 5,010%.
Okay. So it'll be 5,010% with house arrest until you provide proof of employment with the hours to the tether department. Then I will change that order to allow you to work. Still no contact with the complaining witnesses or the co-defendant on the case. And you are to provide that address that your attorney stated to the tether unit as well.
Okay, Your Honor.
And you have it'll be a tether also. I have to state that. All right, anything else?
Thank you very much, Judge.
You're welcome.
Everybody have a great day, please.
You too. You're all set, Mr. Rizzo.
Thank you for calling my case.
You're welcome. You're all set, Mr. Ringler.
Okay, thank you. Have a good day.
You too. Attorney Harris?
Yes, Your Honor. My
Good morning.
client is not on. I've been trying to reach him.
You can wait a little minute?
Yeah,
Okay.
we were going to waive the exam anyway. So,
Okay. All
and
right, so
I've got a jury trial. I've got at 10, so I'll
Okay.
wait.
Attorney Cohen, are you ready on your client's case?
Yes, Your Honor. I have two clients that are both in the Wayne County Jail this morning.
Okay. All right, so we have to wait on the Wayne County Jail. Attorney Vidal, you are ready.
I'm ready, Your Honor.
Good morning to you.
Good morning, Judge, to you and your staff.
Okay, we're on the record. This is the people of the state of Michigan versus Khalid Muhammad Ali Al Bukaidi. Case number 2355487. Mr. Al Bukaidi is charged with count 1, reckless driving causing death, with a felony commission with motor vehicle adult advisory. Today's the day set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Jihad Kadaf, P82492, appearing on behalf of Khalid Al Bukaidi, who's also present via Zoom, and waive our formal appearance in court today and consent to Zoom.
Okay, Mr. Al Bukaidi, can you please unmute your device and turn on your video?
Hey, Your Honor, this is Khalid Muhammad Al Bukaidi, but I have trouble with starting the camera in my phone.
Okay, that's fine. All right, any discovery issues?
Your Honor, I received paper discovery, but there's an integral part to the discovery as stated. I believe that the police have obtained video from a green light store in the area which they used in connection with the charges. I have not received the video, but I do have paper discovery. I am requesting a preliminary exam and would like to have that video prior to, Your Honor.
Okay, Mr. Kirker?
That can be provided, Your Honor.
Okay. So we're all the way in March. Attorney Canals, I'd like to set a date. If you have issues with giving that discovery a week before, then we can have another PCC.
Yes, Your Honor.
Okay, let's see, March 6th is the earliest date. And then moving.
March 6th, would that be for a PCC or the exam, Your Honor?
The exam.
Yes, Your Honor, I can do the exam on the 6th.
Okay, get a time. Do you want to do 9:30, 10, or 10:30?
10:30, Your Honor, if you'd be so kind.
Okay. So that'll be March 6th at 10:30 in person. And if a week before you do not have discovery, just you can log on and Zoom in and we'll discuss it.
Yes, Your Honor. Thank you very much to you and your staff.
You're welcome. Anything else?
No, Your Honor.
All right, you'll have a good day.
You too, Your Honor. Thank you.
Hmm?
I got 3 people coming.
Oh,
This for
it's a full bag.
Oh, no, not too much.
Oh, I'm sorry.
Not too much, yes. Like, yes, the attorneys come here to watch.
Oh, you're a celebrity?
No, I do not. No. I just want to let you all know so you all can let them in.
Thank you for letting us know you're running.
Thank you for all of your hard work.
Very well, anytime.
Got an example? It's on one of those. It's two. So let me double check. Okay, I'm sorry.
Yeah, that was bad like that.
There we go. Please, I don't know.
So it's on tablet.
Should be paid in jail. Oh, today?
You gotta be system.
Oh,
It's in my
yeah.
brain.
I'll put it here.
I didn't see him.
So, yeah, we do think that. Okay.
See these two. He gonna be.
All right. Thank you. Okay. Attorney, let's see. Attorney Brady,
Ready?
good morning.
Good morning.
Ms. Johnson, before you get going.
Yes, ma'am.
Good morning. You're supposed to be here. Usually the J's are supposed to be in traffic, but you're actually on the docket. So I had to check in.
Ma'am.
Your call, I had to check in. Oh, actually, we're gonna call your case now.
Eric Hall is here.
Okay. Yeah, very well. One moment, Attorney Brady, we don't have the file for some reason, it wasn't brought up. Okay, we're on the record as the people of the state of Michigan versus Eric Joseph Hall, 2355543. Mr. Hall is charged with 1 count of police officer assaulting, resisting, and or obstructing. Today is the next step for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Judith Brady on behalf of Eric Hall, P44567. Mr. Hall, state your name for the record, please.
Eric Joseph Hall.
Your Honor, my client would like to waive his preliminary examination and go over to Frank Murphy for further proceedings, please.
Okay, any objection from the people?
No objection, Your Honor.
Okay, Mr. Hall, can you hear me okay?
Yes, Your Honor.
Okay, I'm gonna ask you a series of questions, all right?
Yes, ma'am.
Okay, do you understand that it's your right to have a preliminary examination?
What was that?
Do you understand you have a right to a preliminary examination?
Yes, ma'am.
Okay, and you understand that if you were to hold that preliminary examination, the prosecutor would have to show today as a probable cause standard, not the beyond a reasonable doubt standard, but probable cause, which is a lower standard. They would have to prove that the crime, that the charge that I just read on the docket was committed in the city of Detroit, and that you probably committed that crime. You understand that?
Yes, ma'am.
And that by waiving your exam, your device is muted. Can you unmute it? There you go. And by waiving your exam today, that means that the prosecutor does not have to call witnesses at the exam stage. You understand that?
Yes, ma'am.
Okay. Knowing that information, do you still wish to waive your preliminary examination?
Yes, ma'am.
I'm almost done. Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything in exchange for you to waive your exam? Okay. So I find your waiver to be freely, understandingly, and voluntarily given. So I will have you bound over to 3rd Circuit Court, Frank Murphy Hall of Justice. March 7th at 9:00 a.m.
Thank you,
Okay.
Your Honor. You have a great day, you and your staff.
You as well. You're all set, Mr. Hall.
Okay, thank you, Your Honor.
You're welcome. Have a good day.
You too.
Mr. Huff? Waylon Huff?
Yes, I'm here, Your Honor. I'm sorry.
Good morning. What are you here for today?
I have a CCW charge. My lawyer Andrea said I was supposed to be in Aliyah and Sabree courtroom.
Okay, that's close, but you're a day early. It's tomorrow.
Oh, okay.
So just come back tomorrow. Do the same
Okay,
thing.
thank you.
You're welcome. Have a good day.
You as well.
Okay, so the person who's logged in as iPhone with no video, can you state your first and last name, please?
Devontae Jackson.
Mr. Jackson, do you have a traffic matter today?
Excuse me?
Do you have a traffic matter today?
Yes, it says arraignment on BW.
Bench warrant, yeah. Okay, so I'm going to put the information on the screen for you to take down so you can go to the right court. You should get Judge Larry Williams in 332. And let me tell you two things. One, you need to stop smoking. And two, you need to take the do-rag off your head before you show up to court.
I apologize, ma'am.
So let me put the information up for you so you can get over to the right court.
Okay, thank you, ma'am. I just log into there to his courtroom.
Yeah, the red numbers at the bottom will get you into the right courtroom.
Thank you.
You're welcome. Have a good day.
You too.
Okay, who is calling in from the Wayne County Jail? Can you unmute and state your name, please? What's your name?
Kawan Holiday.
Kawan Holiday?
Yes. Can I go to the breakout room with my lawyer?
Yes.
And how y'all doing today?
I'm fine. How are you doing, Mr. Holiday?
Getting in there.
Your attorney is not, well, I don't know. I'm your neighborhood defender. Not sure who your attorney is quite yet.
I think his name McConnell.
Okay, we're gonna call and get your attorney on.
Thank you.
You're welcome. To the person with the phone number 214-0968, can you unmute your device, please, and state your name? Two 214-0968.
Hello,
Yes, ma'am, what's your name?
Angela
Say your last name one more time.
Faison, F as in Frank, AISON.
Okay, Ms. Faison, I believe you have a traffic matter. You should be with Judge Larry Williams as well.
Correct.
Okay, so this is courtroom 438. We switched dockets, so there's a little confusion.
Okay.
So you know the number that you used to call in?
The 929-436-2866.
Yes, call that number again, and then I'm going to give you the correct Zoom information. Let me know when you're ready.
I'm ready.
So the PIN is 360
360
332
332
0000.
0000.
Yep, so go ahead and call in now.
Thank you, Your Honor.
You're welcome. Have a good day.
Bye-bye. You too.
Attorney Gagne,
Yes, ma'am.
good morning.
Good morning. I'm here for
Um,
Roger Van Zant. I'm wondering if it's the same issue as the last person. The notice to appear says 438, but then it says Judge Larry Williams.
That's correct. I'll put the information on the screen for you.
All right, thank you.
You're welcome.
Okay, thank you.
You're welcome. Have a good day.
Good morning, Your Honor.
Attorney Perkins, you're waiting on Worthington, correct?
Yes, I do need to go into a courtroom, and then when I go in, I'm in 37th district. I just need to power down, and then I'll come back on in 15 minutes if I can.
That's fine, yep. We'll be here.
Okay, thank you. All right,
Uh-huh.
all right. Still no discovery though.
Okay, good to know.
Okay, all right.
And Mr. Holliday, your attorney, finishing up next door, courtroom over, and then, they'll be over here. We put you in the breakout room. Okay. Now, Mr. Worthington?
You're muted, go ahead and say yes again. Yes, good morning.
Good morning, Mr. Worthington. Your Attorney Perkins just stepped into another courtroom. He should be out in about 10 minutes to address your case.
Yes, ma'am.
Yeah, I think you have her forward.
That's for Johnson.
She just come first. Yeah. She said she should be up by 9. Cool down and good at first. I tried. Can't be a real specific sign.
Is that for Johnson?
Yeah.
Miss New?
Not
Miss-
Miss Lou yet. Ms. Johnson, your attorney's on her way up. What's yours?
It's ours.
The hour. I like your style. That's nice.
Do you use this drawing at all? Miss Sabree,
I'm sorry.
you use this drawing at all? I just didn't want to put it on the lower. Yeah.
I just go to 10:30 more. For the, 10:30 March 6th.
So we got a lot of exams on March 8th.
Make sure you stay with the long process. Make sure you don't get out of it before you celebrate. Like, you should be leaving anytime early. 8. Let's see. Actually, not that bad. It's only a 10, 10, 30, and 11. So I gotta squeeze 9, 9.
That's a lot.
Yeah, you just gotta work on getting weights. Oh. Oh. What? Yeah, he does. So that's the problem. So the gentleman with the glasses and the Galaxy phone, what's your name, sir?
Russell Adams.
Morning, Mr. Adams.
Good morning. How you doing,
I'm fine, how are you?
ma'am?
I'm fine. Your attorney was here at 8:30. Can you hear me?
Yes, ma'am.
Your attorney was here at 8:30. He has a jury trial that he's in now.
Uh-oh.
Yeah, you're late.
Oh, man, I apologize.
You were late last time. What's the problem?
No, I overslept and thing, and then my phone was acting up when I was logging in with this thing you gave me.
So I'm just gonna have you on mute and see if he can step out for a moment to address your case.
Okay.
Still no lawyers. You guys are hungry. We're waiting on, all waiting on lawyers. It'd be a little complicated.
Yeah.
We can figure it out. Okay, Ms. Johnson?
Yes, ma'am.
Okay, your attorney is here. She's in person. Okay.
Change my.
Okay, ready for the record?
I'm gonna be hollering right here. This case, the full evidence adjourned to March 9th at 10:30.
Yeah.
All right, thank you.
Ms. Johnson, are the last four digits of your phone number 7518?
Yes.
Okay, I'll give you a call shortly, okay? I have a few more matters in court and then I'm gonna call you.
Okay.
Okay, we are on the record, the people of the state of Michigan versus Ms. Johnson, how do you say your first name?
Aliciana.
Feliciana Johnson, 2355546. Ms. Johnson is charged with one count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Today is the day set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P862282.
And Emily New on behalf of Feliciana Johnson, P85234.
Ms. Johnson, can you state your full name for the record, please?
Feliciana Amber Johnson.
Say it one more time.
Feliciana Amber Johnson.
Okay, is it correct your client is consenting to this hearing on Zoom?
Yes.
All right, any discovery issues?
No, Your Honor, I believe I have everything.
Okay. Are we looking just for an example?
Yes.
All right. I have, actually, let's see. I do have two openings, March 2nd. I have a 10 and 11. I have March 6th and 7th open as well.
I could do the second at 11.
Okay. March 2nd at 11 a.m. Ms. Johnson, your preliminary examination will be March 2nd at 11 a.m. It'll be in person at 36th District Court, okay?
Yes, ma'am.
All right, anything else?
No, Your Honor, thank you. You have a good day.
You too. Ms. Johnson, you are all set, and Attorney New said she's gonna give you a call, okay?
Thank you.
You're welcome. Have a good day.
What was the date on the full thing?
3-2.
Thank you.
Go ahead. Come back.
March
Okay, Attorney Cohen.
Good morning.
Good morning. I have Mr. Holliday on. He wants to speak to you in a breakout room.
That's fine. Thank you, Your Honor.
Thank you, Judge.
You're welcome. Go ahead and hit join, Mr. Holliday. You should pop up in a moment.
Okay.
Don't tell me the number, right? Okay.
549. Seven, 6, 5.
Okay, Judge, you said, what is it? Is it 313?
549, 765.
Okay.
Oh.
Renaissance man. Okay. He's like. Good morning. Can you tell me if this case been adjourned? Robinson. And it's a person. She's supposed to call.
Not to my knowledge about it.
I tell him he just gotta wait, he gotta wait.
I don't ask if it's adjourned or cold. The appearance is still.
She just
present on our mind. Yeah. Oh, it's attorney 9. I don't. Attorney 9. Attorney Harris, welcome back.
Yes, welcome back. Thank you. I believe my client, Mr. Adams, is on.
Yes, he decided to wake up and show up to court today.
Okay.
You need to speak to him?
No, I spoke to him last night, Your Honor. We're going to waive the examination.
Okay. All right, let's call the case. This is case number 2260338. People of the state of Michigan versus Russell Tyrone Adams. Mr. Adams is charged with 1 count of weapons carrying concealed. Today's the day set for a probable cause conference appearances.
Alexander Dricker on behalf of the people, P 86282.
Good morning, Your Honor. Wyatt Harris, P54891, on behalf of Mr. Russell Adams, who appears via the Zoom with the court's permission.
And Mr. Adams, can you state your full name for the record?
Russell Adams.
Okay, Attorney Harris, I should say, you just mentioned your client wishes to waive his exam today?
Yes, ma'am.
Okay, Mr. Adams, I'm gonna ask you a series of questions, okay?
Yes, ma'am.
If you don't understand the question, please let me know and I'll ask it again.
Okay.
All right, is it your wish to waive your exam today?
Yes, ma'am.
Oh, I'm sorry, Mr. Kirk, do you have an objection to the waiver?
No objection, Your Honor.
Okay, so Mr. Adams, do you understand you have a right to a preliminary examination?
Yes, ma'am.
And that if you were to demand your exam today, the prosecutor would have to show as a probable cause standard, which is a lower standard, it's not the beyond a reasonable doubt standard, but probable cause standard, that the charge that I just read off was committed in the city of Detroit and that you probably committed. Do you understand that?
Yes, ma'am.
And that by waiving your exam, the prosecutor does not have to show or prove anything today.
Yes, ma'am.
And knowing that information, do you still wish to waive your exam?
Yes, ma'am.
Did anyone force you or threaten you to waive your exam today?
No, ma'am.
Did anyone promise you anything in exchange for you to waive your exam?
No, ma'am.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Court, Framework Hall of Justice, for an arraignment on the information for a date of March 7th at 9 a.m. Anything else from either party?
No, ma'am.
No, ma'am.
All
No,
right,
Judge. Thank you very much.
thank you. You can log on, Mr. Adams.
All right, thank you.
You're welcome. Mr. Worthington, I'm still trying to see if your attorney or Mr. Perkins is wrapping up. Okay, we're ready on Mr. Holliday.
Yes, Judge, I was just trying to make a quick phone call to see if I could verify Mr. Holliday's address for a bond motion, but
You can, go ahead. Take
yeah,
time.
I'll be right there.
Okay. Attorney Vasquez, good morning. Attorney Vasquez,
Good morning.
how are you?
I'm actually just covering for Attorney Carla Membrell. She has Edward Robinson up this morning and she needs an adjournment. She's in trial today.
Oh, we don't need it. How long is her trial lasting?
Okay, so she says she's in it today. And then tomorrow is their motion day, so she can appear tomorrow. But if not tomorrow, then anytime next week.
So she has something tomorrow, she has an exam tomorrow anyway here, so she can come 8:45 tomorrow.
Okay, thank you, Judge.
But wait, I have to go on the record and I need the defendant in here and I need the prosecutor to not, or to be okay with that. So
Okay.
actually, I have to call the case.
Okay.
May object to it. That's an actual. And the other one is not. So they both really. Okay. Okay. All right, Attorney Cohen, give me one moment. I'm just gonna put this adjournment on the record. Okay, we're on the record as the people of the state of Michigan versus Edward Robinson Jr., case 2258187. Mr. Robinson Jr. is charged with count 1, controlled substance delivery, manufacture, cocaine, heroin, or another narcotic, 50 to 449 grams. With the second or subsequent offense notice. Count 2, controlled substance delivery, manufacture, cocaine, heroin, or another narcotic, less than 50 grams. Second or subsequent offense notice. Count 3, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. The second or subsequent offense notice. Count 4, weapons, ammunition, possession by a felon. This is a habitual offender fourth offense notice. And Mr. Robinson Jr. is defendant number 1 on this case. Today is the day set for a preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Deja Vasquez on behalf of the defendant, Edward Robinson. I am stepping in for attorney Carla Mabril. My P number is P85060.
And Mr. Robinson, good morning. Can you state your full name for the record, please? And Attorney Vasquez, can you put on the record what your request is, please?
Yes, Your Honor. At this time, we are requesting an adjournment. Attorney Mabril is in a trial in Grand Rapids. We are asking for just a short adjournment to tomorrow at 8:45 a.m.
Any objection?
No objection, Your Honor.
Okay, seeing there's no objection from the people, I will grant that brief adjournment to tomorrow, 8:45 a.m. Mr. Robinson, you heard the news, your attorney's in Grand Rapids in trial still. So come back tomorrow in person, 8:45, we'll call your case first, okay? All right, anything else?
No, ma'am.
No, Your Honor. Thank you.
Okay, you have a good day. I'll see you tomorrow.
Good day.
Okay. Okay. Ready on holiday. It should be Tuesday. Okay. Okay, here on the record is the people of the state of Michigan versus Kawan Deontay Holiday, 23-55503. Mr. Holiday is charged with count 1, home invasion, second degree, count 2, burglar's tools possession. Also, case number 23-55490. Mr. Holiday is charged with count 1, home invasion, first degree, count 2, weapons, felony firearms. Today set for a probable cause conference on both cases. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Services by Jonathan Cohen, P86151, appearing by Zoom with Mr. Holliday, who's appearing by Zoom from the county jail.
Mr. Holiday, can you state your full name for the record, please?
Juan Deontay Holiday.
Okay. I guess we'll start with any discovery issues.
Your Honor, I'm not sure on the discovery. I need to double check whether we have everything, but I did email a motion to withdraw because of a conflict in this case. That was sent to Your Honor and Mr. Kirker, I believe yesterday.
Oh, let's see. Where'd you send it to? The courtroom? No, up here, that's right here. Yesterday.
Yes, Your Honor. I sent it directly to you based on a prior message. I think you had sent that we didn't have a clerk necessarily to send it to.
Yeah, thank you. For some reason I didn't see it, but I guess. So Mr. Holliday needs to speak to a new attorney.
That's correct. I wanted to make a motion on his behalf with respect to bond. I don't know that the conflict we have would necessarily prevent me from doing that. But that being said, if a new attorney is appointed today and could make that motion on Mr. Holliday's behalf, obviously that would also be fine.
So before you withdraw you or remove from the case, if you're most familiar with Mr. Holliday, that would make more sense for your argument for his sake. First, let's start with the motion to withdraw. Mr. Kirk, did you receive it?
I did receive it.
Okay, so after I hear your bond motion, then we'll address. Whenever you're ready, Attorney Holliday.
Thank you, Your Honor. Mr. Holliday is 26 years old. He's a lifelong resident here of the Detroit area. He has his GED he obtained in 2017. Prior to his being arrested, he was working as an independent contractor doing residential and commercial construction, and believes that he still has that job available to him were he to be released. He was also doing residential and commercial cleaning, as well as moving jobs through Flat Rate Moving Company. He helps out around the neighborhood doing landscaping and lawn mowing just for neighbors as a favor. He doesn't get paid for that. And I'll leave it up to the people as far as any prior record. I'm unaware of any significant prior criminal record, but certainly if they have access to something, speak up. I don't believe Mr. Holliday has any failure to appear history. And in this case, as far as the likelihood of conviction, in reviewing the discovery, although it appears Mr. Holliday was sort of apprehended directly after these alleged home break-ins with some property in his possession to indicate that he may have gone in. Mr. Holliday also disclosed that he was essentially forced to enter these homes at gunpoint by another client, that's the basis of the conflict. My office had previously represented this other individual who Mr. Holliday indicated had forced him to commit these crimes. So there is at least the possibility of a duress defense in this case that the court should take into account. Mr. Holliday would be able to stay at 13597 Long Acre. That's the address he reported staying with family. He has two cousins that stay at that address. And again, he would like to get out to be able to work, get back to work. Also, he disclosed to me that he has several significant health issues that are not being properly addressed while in the county jail. He reported being involved in a very serious car accident in 2021 that caused significant brain injury. He suffers from memory loss. Also, he has asthma and I guess has been quite sick while in the county jail, having breathing difficulty as well as vomiting, and is not getting adequate medical care, according to Mr. Holliday. So I'd ask the court to consider those issues as well. His bonds were already lowered to very low bonds. I think they're 5,000, 10% in each, with GPS tether allowing him to leave for work. But unfortunately, just due to his situation and the financial situation of his family, unfortunately, that is still an unattainable bond for him. So again, given everything, we would ask the court to consider issuing personal bonds. They could certainly be in higher amounts, but personal bonds with GPS tether, so that he could be out, and obviously he would stay away from the complainant residences in these two cases. Thank you for your consideration.
People just insist on the no contact, leave it to the discretion of the court.
Attorney Cohen, you did mention several things that moved me to adjusted bond. I will take your suggestion. I will change it to a personal bond, the $100,000 personal bond on both cases. Also, that will be with the tether. Everything I'm going to put on here is for both cases. So tether, and I am going to place a house arrest condition on here with the exception for medical visits. And once he provides proof of employment, the tether unit, and the time in which he'll be working, then he can leave for that. Other than that, he's not to leave. And I have the address down here on Long Acre as his place where he will be staying. No contact with either complaining witnesses or the locations that the incident happened in. And I believe that covers everything.
Thank you very much, Your Honor.
You're welcome. Mr. Holliday, do you understand what I just said?
Thank you, Your Honor.
Okay, do you understand? I didn't hear you. Did you understand there all the conditions I just gave you?
Yes, I did. Thank you. And I will listen to everything y'all said. Thank you, ma'am.
Okay, you're welcome. Anything else?
Not with respect to bond, Your Honor, no.
Okay, so Mr. Holliday, because Attorney Cohen has a conflict, we have called to get you a new attorney. So you have to wait a little bit longer so you can talk to your new attorney, okay? So just stay on. That person should call in soon and then we can, oh, you know what? I didn't address the motion to withdraw. So Attorney Cohen, I received your motion to withdraw based off of what you said also during the bond motion. I'm going to grant that motion.
Okay.
Thank you, Your Honor. I'll try and stick around. I have another client in custody and maybe I can find out who the new attorney is so that I can send over all the discovery we do have.
Okay, that'll be great. So just hold tight, Mr. Holliday.
Okay.
Mr. Holliday, can you have a deputy come over?
Say that one more time, Judge.
Can you have a deputy come over to the screen?
She needs to come over real quick. She want me to stay right here. Here you come, Judge.
Thank you.
Oh, yeah.
Good morning. Do you have any other defendants for me other than Mr. Holliday?
I don't believe so.
Okay, I didn't want to hold you all up. Mr. Holliday is getting a new attorney. So it's gonna take a few minutes or so.
Okay, no problem.
Okay, Attorney Cole, did you have something?
Yes, Your Honor. My other client, Israel Clary, is in custody, so I don't know if he's still going to be brought over or not.
Okay. You know, he might be, you know, if he's in Division 2, he might be behind Mr. Worth.
He was in Division 1 when I saw him a few days ago.
Okay. Where is he? Division 1. He's in Division 1. Thank you. Okay, Attorney Cohen, he is in Division 1.
Understood. I'll hang out. Thank you.
Okay.
Excuse me, Madam Clerk.
Yes, sir.
You guys are looking for Israel Clary.
Yes, sir.
All right, it's just gonna be a minute if I have to change out Worthington. I gotta go get Cleary now. So give me a minute to take Worthington back and then I'll get Cleary instead.
Okay, thank you.
There's no word on Mr. Perkins about when he may be back, right?
I'm sorry.
No word on when Mr. Perkins may be back?
No, I don't have any word as of now.
Okay.
Okay, thanks.
So who has Mr. Clary?
That's Mr. Cone. Mr. Cone.
Okay,
Mr. Cone.
all right, thanks.
Attorney Cone.
Right, so we just, that's what we do. Our neighborhood.
The deputy said they're gonna switch him up right now.
They say they'll switch it? Oh, that's all.
It moves a Worthington.
Okay. Good job. You know that.
Yes.
Good morning, Attorney Manlio.
Good morning.
How you doing today?
Good, good. Just got a call to Zoom in on Mr. Holliday.
Yeah, okay. So I have Attorney Cohen, who has just been removed from the case. He is going to help and assist with providing discovery and I'm gonna put you in the room with Mr. Holliday to speak to him. Attorney Cohen, do you want to go into the room for a minute to kind of pass on?
Yep, that'd be fine.
Sure, perfect. Thank you.
All right, so Mr. Holliday, we're going back into breakout room.
Okay.
Okay, we ready to call Mr. Worthington's case?
Yeah, I'm ready, Your Honor.
Okay. We are on the record as the people of the state of Michigan versus Calvin Worthington, 2355118. Mr. Worthington is charged with count 1, assault with intent to murder, count 2, weapons felony firearm, count 3, assault with intent to do great bodily harm less than murder, count 4, weapons felony firearm, count 5, assault with a dangerous weapon, felonious assault, count 6, weapons felony firearm, count 7, weapons firearms possession by a felon, count 8, weapons felony firearm, count 9, weapons ammunition possession by a felon, and count 10, weapons felony firearm. Today is the day set for another probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Good morning to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Worthington.
Mr. Worthington, can you state your full name for the record, please?
Calvin Worthington, Your Honor.
Thank you. Good morning.
Good morning.
Okay, so we have an exam scheduled for the 24th, and this date was set to make sure that discovery issues were resolved. Attorney Perkins, still having issues?
I just received a access evidence.com link from, I believe, from the prosecutor. I don't know which prosecutor. I have not been able to open it, but it just came through maybe at 9/11. So I have not had an opportunity to look at it. It's 2 zip drives. So I'm assuming that's everything. I can only assume because I haven't had a chance to look.
Okay, Mr. Kirker, can you speak what was sent at all?
I cannot, since I haven't been talking to the officer in charge, but I believe with all the body worn cam that was being sought after in this case.
Okay. And will you be handling this case on the 24th or Mr. Decker?
Which date's the 24th?
It's a Friday. Okay.
Oh, yeah, Your Honor, is it possible to move the date up or to move it to Monday? Because I have, I regret to inform that I had, my mother-in-law passed away and I have a funeral in Louisiana. And I don't.
Does 10 o'clock work?
On which date?
On Monday?
Just a moment, Your Honor.
Yes, it does.
Yes, it does work, Your Honor.
Okay, I'll give you a little more time to review the discovery too.
Yes.
Okay, so we're adjourning to Monday, February 27th at 10 o'clock. Is there anything else? I feel like I missed something.
No, well, Your Honor, I do want to address the issue of bond. I know the court did already, but, I think it's, the bond that's currently set and, and I'll be completely forthright. Mr. Worthington has a hold out of Macomb County, but, the bond essentially is a no bond. I mean, this is not even something that would be in any average individual's ability to make. So I don't know if the court wants to address it now. I know you did, when I first came on the case, the court did adopt, I think there was a screening unit's report, but I did at least want to put that on the court's palette so that if the court's not going to address it today, I definitely want to address it at the time of the exam. But, I think some reasonable bonds should be set, and I just don't see this bond as being reasonable for Mr. Worthington.
Okay, so from my half days, the file was not set up. I have Mr. ROA, and it says here that the bond was lowered to 100, oh, I see, to $1 million cash or surety from $1 million cash. Is that correct?
Correct.
Okay. And I don't know, did we ever, I don't remember having a DSU report. Did I go through that? You said I did. I don't have.
You made some record at the last time, not the last time, but the time before we were in court. You indicated that he came up for review. I believe the chief judge did review it and kept the bond as the same because there was a bond, how your system works now. And when that happened, you just adopted what he said, and that I didn't have as much information about the case to really argue for him. And also, I recognize that if he is released, we still have to go take care of the hold in Macomb County. So, for logistical purposes, I don't know what Macomb County is going to do. But, after the conclusion of this exam, I'm definitely going to be asking the court for a reasonable or a personal bond for this individual. This is something that happened at his work. It's something that was unprovoked by him. I don't know if I'm doing Mr. Worthington justice by asking for a bond that he can make right now, and then he goes to Macomb County and we can't have our exam. So that's the quagmire that I'm in right now.
Okay. I'm printing out the DSU report. I need to refresh my memory because I don't have the file notes or anything.
Okay. Well, what I'll do is I'll provide a memo for the court when we have the exam.
Okay. All right. And I reach out.
Okay.
So we'll have a writ for 27 from Mr. Worthington to be in person.
Okay. All right. Thank you, Your Honor.
So Mr. Worthington, today you're all set. Your exam is Monday at, I believe you said 10 o'clock?
Yes.
10 o'clock in person at 36th District Court, and Attorney Perkins will address bond on that day. Okay?
Thank you, Your Honor. Yes, ma'am.
Okay, see you, Mr. Worthington.
All right, thank you. See you later.
Okay, Attorney Cohen. Everybody else now? Thank you. Got about 5 more seconds and they'll come out. Okay, got everybody back? Okay, Attorney Cohen, do you need to be on the record? Or are you all set?
Not for Mr. Holiday, no, thank you.
All right, thank you for your help. Okay, we are back on the record as the people of the state of Michigan versus Juan Holiday. 2355490 and 2355503 appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Maria Manarino, P39531 on behalf of Mr. Holiday. Joins us via Zoom. Mr. Holiday, please identify yourself.
Juan Beyonce Holiday.
Okay, Attorney Manarino, you have had the opportunity to speak to Mr. Holiday briefly.
Yes, I spoke with Mr. Holiday. I got some background from Attorney Cohn. At this time, Judge, what I'd like to do is have an adjourned PCC date so I can get a hold of the discovery, go through it with Mr. Holiday and determine how we are going to proceed.
Okay. How much time?
Well, my concern is that it's my understanding is that there is an order already reducing the bond to personal with GPS tether. So it's a matter of when he's going to be fitted with that and released. So I don't know if we should put it off, perhaps a week. Hopefully he will get out and we'll have an opportunity to go over the materials at that time.
Finally, March 1st.
I think that'll work, yes.
Okay, 9 o'clock.
Yep. All right, Mr. Holiday, did you hear that the PCC, if you get out before then, please make sure you will contact me and we'll figure out how we're going to do this, okay?
Okay, I will.
Judge, I don't know if he has access to take my number down where he's at. Is there a deputy over at the Wayne County Jail who might be able to pass along a phone number?
Mr. Holiday, can you grab the deputy again for me?
Yeah. Hey, Deb. Excuse me, Deputy. Hey, Deb. Excuse me. Here you go.
Thank you.
Hey,
Deputy, do you have the ability to take down my number for Mr. Holiday to make sure he has it?
No problem. He said 1 second, ma'am.
Is your phone number? Thank you. 248-761-7347.
So I have a 248-761-7347.
Correct. All right. Mr. Holiday, I don't want to lose you. So if you get out before we can connect, please make sure you call me right away.
I'll contact you the first day I get up?
Yep.
Okay, that's what I'm gonna do. I got you.
All right. Thank you, Judge. See you next week.
All right, you'll have a good day. Okay. And to the gentleman who just sat down in Division 2, what is your name, sir? Go ahead and unmute your device or ask the deputy to unmute.
Israel Landis Clary.
Okay, good morning.
Morning.
All right, we are on the record as the people of the state of Michigan versus Israel Clary, 2355490. Mr. Clary is defendant number 2 in charge with the following: count 1, robbery armed; count 2, robbery armed; count 3, weapons, felony firearm, and count 4, weapons, felony firearm. Today is the day set for a probable cause conference appearances. Oh, I just called Mr. Cleary.
Oh, Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing by Zoom with Mr. Clary, who's also appearing by Zoom from Wayne County Jail. Mr. Clary, can you go ahead and state your full name?
Israel Alandris Clary.
Thank you. Okay, Attorney Cohen, any issues with discovery?
No, I believe I have both paper and digital that we need to proceed for setting the exam.
Okay, so I just realized I set the exam date already for Mr. Reeler for March 8th at 10:30. Does that day work? Hopefully it does.
It does, Your Honor. That works for the defense.
Great. All right, let's see here. So March 8th at 10:30. Anything else?
Yes, Your Honor. We would like to be heard on the matter of bond for Mr. Clary.
Go right ahead.
Thank you, Your Honor. Also, to clarify before I begin, it looks to me like bond was previously reduced to $10,000, 10%. But there's a lot of sort of contradictory information. The jail shows it as 10,000, 10%. The Register of Actions, though, still shows $100,000 bond. And so I just wanted to clarify before I began what our starting point is.
Okay, I have here 10,000, 10% from Judge McConicle at a bond redetermination hearing on
Okay.
13th.
The Register of Actions seems to still show $100,000 cash or surety, but that 10,000 matches with what Mr. Clary indicated as well as what the jail shows. So with that as our starting point, I am asking the court to consider a personal bond, perhaps again, a higher personal bond than has currently been set. Mr. Clary just turned 21 today. It is his birthday. Happy birthday, Mr. Clary.
Thank you.
He is a longtime resident of the Detroit area, Southeast Michigan area. He has very close family ties here. His mother, Heather, I've been in contact with her. She indicates that Mr. Clary would be able to stay with her were he to be released. And if the court found it necessary to have a GPS tether, he could be tethered to that address at 365 Genesee Street in River Rouge. He did not graduate high school. He unfortunately stopped going to school in 12th grade, but does have a plan to get his GED. He was working 2 different jobs prior to his arrest, and has the capacity to work full-time at Untouchables, which is an automotive repair and detailing place in Ecorse, very close to where his mom works. I think it's walking distance even. He has, again, other close family members, a big sister who's 22 and a big brother who is a member of the, I believe it's Ecorse PD, the police department. He's actually a member of the SWAT team. So he has close family members that are willing to vouch and sort of make sure that he keeps his nose clean while he's out and make sure he gets to court. Mr. Clary, unfortunately, has also been having some significant anxiety and depression while in custody. Very recently, his grandmother, who helped raise him for for a lot of his childhood, passed away, I think last year. And then his grandfather, who was also very pivotal in his life, had a stroke and unfortunately no longer recognizes him. So he has lost 2 very important family members to him in the very recent past. And I think that's been very, very difficult for him emotionally. His mother is aware of these issues and has also committed to working with Mr. Clary to help him seek some counseling and therapy while he is out of custody. So I think they have a good handle on what the issues are and a plan in place to help deal with that anxiety and depression. He's also been working closely with my social work staff here at the office. Ms. Deshawn from my office has seen him in custody there and plans to continue working with him on these issues. But again, Mr. Clary is a young man with, I think, minimal record and no failure to appear that I'm aware of, no record of missing court dates. I think that with a personal bond and GPS tether, that would certainly, with his family support that he has, will ensure that he will come to court. He does not know these people, the complainants in this case. They were known to Mr. Ringler, or rather the complainant knew Mr. Ringler, but not Mr. Clary. So as far as, I guess, the last point I would like the court to take into consideration, when it comes to the factor of the likelihood of conviction in this case, one of the primary sources of identification here, as far as the other individual besides Mr. Ringler involved in this alleged armed robbery, was based on Mr. Clary being picked out of a six-pack, a photo lineup that was presented to the complainant, one of the complainant witnesses. And this photo lineup is extremely troubling insofar as the only one of the only descriptors given of the assailant was that he was an African-American male. The photo lineup that was generated, for whatever reason, it is one of the most bizarre lineups I've seen in my many years of practicing. I will show it on the camera for the court if the court is able to see it. It is a six-pack lineup composed of primarily Caucasian and/or it appears to be Hispanic individuals. And then there's Mr. Clary here, who is, I think, arguably the only individual that one might remotely even consider to be African-American. So this is truly a lineup of one in this particular case. So with all of that, I'd ask the court to consider a personal bond. Thank you.
People would insist upon a no contact and leave it to the discretion of the court.
Okay, Attorney Cohen, I am going to adjust bond for Mr. Clary with the following conditions. It'll be a personal bond with $100,000, tethered at the address of 365 Genesee and River Rouge. That's his mother's house, correct?
That is correct. Heather Leach, Leitch is her name, and that's her address.
Okay, Mr. Clary, I'm going to put you on house arrest, however, with a couple exceptions here. You can leave, or if you have to go to in-person therapy sessions, or if you have to go to work. The only way that you are allowed to go to work is if you provide verification to the tether unit that you actually have employment. And you must also provide your work hours to the tether unit so that there won't be any issues. There's no contact with the complaining witnesses or visiting the address 11741 Terry Street in the city of Detroit. I believe that's it. So with that, Mr. Clary, let's see. I will see you on March 8th at 10:30. It'll be in person. Mr. Clary, do you understand that?
Yes, ma'am.
In person, 36th District Court, on time at 10:30.
Thank you.
I will stress to you one more time, Mr. Clary, I know your attorney said you don't know the complaining witnesses, but I'm going to emphasize no contact, indirect or directly, nothing through social media or through anybody else. You understand that?
Yes, ma'am.
Anything else?
No, ma'am. Thank you very much.
Thank you very much, Your Honor.
All right, we'll have a good day.
You too. Thanks. Mr. Clary, call me when you're out, okay?
Okay.
Thank you.
All right, have Attorney Cohen.
I'm sorry, ma'am, what'd you say?
I'll just say have a good day.
Oh, thank you so much. You too.
Okay. Okay, ready? DeAndre, Carol?
So it's just that one treatment.
I just put C motion. It got too much.
He's on around the corner.
I got it all written down. You have it written down. Okay, I should be able to talk. I'm sorry, you need a break before you. Okay. What's 2 weeks? This is 2 weeks same together. Co-defendants. Let me write one at a time. I'm gonna start typing. Yeah, the PDF. There was some of this, because I noticed there's some typing to the file. Martin wrote it. Okay. The business said, he was in Mission versus DeAndre Dewan hearing 2260261. Mr. Heron is charged with 1 count of weapons carrying concealed, except for preliminary examination appearances.
Alexander Kirker on behalf of the people, E86282.
Good morning, Your Honor. Alex, so, name of the member, so, Detroit, 5948, and we have Mr. Heron, President. Council, speak at the microphone. Can you say that one more time?
Yes, sorry.
Alexander Detroit, witness for Representative Detroit, E85948, Mr. Heron, who's President.
And Mr. Heron, can you speak loud and state your full name, please?
DeAndre Jawan here.
Thank you. Right, are both parties ready to proceed?
Yes.
Your Honor, at this time, one of the necessary witnesses is here, but the other is, I spoke with one of the witnesses, and his partner is still on administrative leave, apparently was involved in the shooting, and hasn't been cleared to return to work yet. So people would ask for a pre-determined.
Your Honor, this is the third adjournment of the matter. We have postponed this date already, I believe, 3 weeks for this administrative leave. This case, I believe, happened in the end of October. So it has been months and months that it is pending. At this point, Your Honor, we are requesting that the case be dismissed.
Is it correct? I see on here, I don't know who's handling it. He had Stanford Jones. Was before.
It was before Jones, I believe, a number of times, yeah.
Okay. It says here set for January 26th, and then February 21st, today. I see one adjournment for officer on administrative leave. Okay. And Mr. Kirker, do you have the date as to when you'll be available?
I believe the officer said by next week, but I can certainly go and make sure that that's the case, so that. Again,
If you give me a date, then I will consider a motion to adjourn. If there's no date.
can I quickly go?
Sure.
The additional adjournments as well, Your Honor, they were, I believe, due to the initial discovery of the video.
Okay. Did you get that?
I think we did. The initial adjournment, I believe, were due to discovery, and that it took a number of weeks to get the digital discovery sent out.
Hello,
Yes, what's your name?
Ann Johnson.
Ms. Johnson, do you have a traffic matter?
One second. The case number,
No, what type of case are you calling in for?
false info ID.
Okay, so you should be in courtroom 332. So I'm going to give you the information. Let me know when you're ready to take down the Zoom ID.
I'm ready.
Okay, so you know that number that you dialed, the 929 number?
Yeah.
So dial that number again, and then when, you're asked for the ID, the Zoom ID, type this number in. You ready?
Yeah.
360
60
332
32. Oh,
000.
you said 332000.
It's 40, so 0000.
Okay, thank you.
Well, have a good day. Okay, we're back on the record on Mr. Herring. Mr. Kirker, did you speak to someone about a date for this officer?
Yes, I just spoke with one of the troopers out there. He said a week from today, so February 28th.
Okay, and you did say something. Mr. Kirker was out on the hallway for you show regarding other adjournments.
Yes, I believe the initial adjournments, Your Honor, were due to discovery. It took, I believe, a number of weeks to receive the digital discovery. Mr. Heron has been present at every hearing. He has traveled to court. I believe this is his third time taking off work in the morning to travel to court for a case that was initially brought in November. Again, for those reasons, we are requesting that the court dismiss this case.
Okay, what I'm going to do, I'm going to allow for the adjournment because we have a date. Officers, make a motion, and I will like to do this. Mr. Herring, I'm going to allow for the people that have the adjournment. This is the first time this is for me. I understand people coming and making questions. I'm going to allow, since they have a date for the officer to come, whether he comes or to a date that's convenient for the defense. If he doesn't show up next week, then and I like the business. Okay. All right. So 28th, I have you're in here at 9 o'clock.
I believe I am in front of you at 9 o'clock. So if there's a time after 9 o'clock.
Except for 9:30.
Thank you.
All right, we're off the record on this here.
Hello? Hello?
Yes, good morning.
Yes, could you send
Yes,
me,
I'm
can you send me to the breakout room with the prosecutor on Van Zant, please?
You're supposed to be in 332. This is the exam docket now.
Oh, 332?
Yeah, do you need the Zoom information?
Is it just 33?
360-332-0000.
Okay, thanks.
Ma'am, are you still on the line?
Yes.
Okay, go ahead and log off and dial into those numbers I gave you.
Okay.
Okay, we're on the record as the people of the state of Michigan versus Adante Kennard Jones, 2355089. Mr. Jones is charged with 1 count of weapons carried concealed. Today is the day set for preliminary examination appearances.
Alexander Kirk on behalf of the people, P86282.
Veronica Walrath with NDS on behalf of Mr. Jones, P85665. Mr. Jones is present in the courtroom.
Mr. Jones, can you state your full name for the record, please?
Adante Kennard Jones.
Good morning to you. All right, both parties ready to proceed? Yes. Your Honor.
Yes, Your Honor.
Okay, any preliminary matters?
None from the people, Your Honor.
Okay, from the time. All right, and no OIC? Okay, all right, Mr. Kirk, you call your first witness.
This time the people call Officer Deshaun Perry.
Good morning. All right, so the court order and I'll swear you. You swear to tell the truth and nothing but the truth. All right, have a seat. I think you know who's in. Start. Oh, that's it.
Apologies.
No, no.
Yes, I need to use video.
Yeah.
It's disrupt the Zoom.
Okay, whenever you're ready, Mr. Perry.
Good morning. Could you please restate your name for the record?
Deshaun Perry.
Are you currently employed?
I am,
Where are you currently employed?
Detroit Police Department,
And in what capacity are you employed?
police officer,
How long have you been employed as a police officer?
3 years.
Were you employed as a police officer on January 8th, 2023?
Yes,
Did you in fact work on that date?
I did.
Were you by yourself or with a partner?
My partner, Officer Flannel.
Officer who?
Flannel?
Flannel?
Yes,
Thank
Were you in full or modified uniform?
modified uniform,
Could you describe that uniform?
green pants, a black vest with Detroit Police on the front and the back.
And did your duties as a police officer take you to an area at or near 14241 West McNichols Road?
Yes,
That in the city of Detroit,
yes,
county of Wayne?
yes.
And what brought you to that area?
Just routine patrol. I walk inside the liquor store. Once I walk inside the liquor store, I observe the male standing at the counter, I guess preparing to pay for his items. When I walk in, I observed a black firearm inside of his right pants pocket.
And can you describe that firearm?
Like I said, it was a smaller black firearm, but the handle was protruding from his pocket.
And what color was the handle?
Black.
And do you see that individual present in the courtroom today?
Yes, he said my defense counsel.
Could you point him out and identify an article of clothing he is wearing?
Yes, he has a tan coat on.
You want to let the record reflect the identification of the defendant?
So reflect.
And what happened after you saw this firearm?
After I saw the firearm, I looked back at my partner, advised him of my observation. I then looked back towards the male, whose right side of his body was pinned against the counter. I went and engaged the male, asked him was he a CPL holder. He kind of ignored my question. I asked again, he once again didn't answer my question if he was a CPL holder.
So when you say he was pinned against the counter, can you describe what you mean by that?
When I first walked into the store, his right side was just, he was standing like facing the counter. But after, I guess we walked in, I looked away and I looked back at him. His right body was pinned against the counter.
And what happened after you asked him if he was a CPL holder?
He didn't answer the question, so I went to recover the firearm, and it was no longer in his pocket.
And when you say you went to recover a firearm, the firearm, what do you mean for that?
I went to take usually when I ask somebody if they're CPL holder, they say yes or no. In this situation, he didn't. So by him not answering my question, I just want to recover the firearm until we verify if he's a CPL holder or not.
And what did you do to recover the firearm?
I had his I went to recover it, but it wasn't there, so I pat the pocket down to see if it was inside the pocket, but it wasn't. And shortly after not even shortly after, I observed my partner was recovered the same firearm I observed in the pocket off the counter that was right in front of him.
And where on the counter was it?
Directly in front of him, he was standing at the counter preparing to pay for his items, and the firearm was right there in front of him.
Was the defendant the only person in line?
He was the only person in line, but he was the only person close enough to put that firearm right there.
Was he the first person in line?
Correct.
And how far away from him was the firearm?
A foot maybe?
And did you observe your partner recover the firearm?
Yes.
And can you describe the firearm?
It was a black, smaller firearm, it's a Psy SCCY, I'm not sure of the model.
And what did you do after the firearm was recovered?
Detained the male in handcuffs, walked him to our scout car, and verified that he was not a CPO holder.
Did you once again ask him if he was a CPO holder?
Yes, I asked him multiple times.
Did he provide a CPO?
He did not.
Was a lien search conducted to determine if the defendant had a valid CPO?
Yes, it was. He was a CPO holder at one point, but he was suspended.
Objection to take your stated presence of lien on federal hearsay, so we think that you testify a lien search was done, but not to the contents of the lien search or the truth of the matter. Ms. Brock?
The lien search is a computer, so it can't be hearsay. What the computer tells the witness.
I think it's just a matter of whether Officer Perry did the search himself or not.
Did you conduct the lien search?
No, I watched my front officer from the door.
Did you observe the results of the lien search?
Yes.
And from your observations, did you determine if the defendant had a valid CPO?
Yes.
And what were the results of the lien search that you observed?
Negative results, no CPO.
You're saying that he had a CPO at some point?
Yes.
And what did the lien search say about that?
It was suspended.
And did the defendant receive notice that his CPO was suspended?
Yes, personally, he was served a verbal notice.
And was the weapon placed into evidence?
It was.
Do you recall the evidence tag number?
I don't, that's in my report though.
Reviewing your report, Josh, your report.
Yes.
May I approach you?
Yes.
Do you recall the evidence tag number?
Yes.
And what was the evidence tag number?
689-212-1.
No further questions, John.
So when you entered the current car, you said you saw something in his pocket.
Yes, and I saw a firearm in his pocket.
Okay. In his right hand pocket.
Yes.
And at that time, he was facing away from you, correct, towards the counter of the store?
He's facing the counter, but his right side was to the
Okay. Was this the front or the back pocket? Front pocket, and you were able to see this front pocket from behind?
It wasn't behind, he was facing the counter, his whole right side was visible.
When you approached, Mr. Jones was paying, or I don't know, was preparing to pay,
Yes,
and he had his wallet out, correct?
I believe so.
Right, he had his wallet in both hands?
I believe so.
Wallet in both hands? And his wallet was a dark brown color?
Okay,
Okay, do you agree?
I'm not sure.
You're not sure? You didn't have your body cam on this, did you?
I did.
The body cam that I have for you doesn't start that now. Would you agree with that?
Okay.
It doesn't start. It doesn't start until they're outside of the store.
Okay, so I was wearing Officer Clown's body cam.
You were wearing Officer Flannel's
I
body
was.
camera? Okay, in that case, I'm sorry, I thought that I was going to.
That's my
ask the other
fault.
person to authenticate it, so
I'm
would you
sorry.
mind if I approach you with that body camera?
No problem.
Okay. Your Honor, could I approach the witness?
Yes.
That's what I was wondering.
Okay. I'm sorry, I'm gonna repeat for the reporter, and I'm so sorry. Would you agree that that's the body camera that you were wearing that day?
Correct.
Okay. Based on the witness's identification, I'm going for the admission for exam of the time for closing to the A. Any objection?
No objection, Your Honor.
Okay, this is exhibit A. And could I play that on the, or I'll give you 12 holes, please. Okay, thank you. Thank you. I only need to play the first 30 seconds, so I'm just going to start that and then pause. Is this you entering the party store?
Yes.
That person in the white shirt, Mr. Jones?
Yes.
Okay, and we can pause to see, does it appear that he's facing away from you?
That's what it look like, yes.
Okay, does it look like his front right pocket would be visible to you at this angle?
Not from that angle, no.
Mark our statement of record, this is at the 16th second mark.
Yes, Your Honor, thank you. This is at 60 seconds for the record.
At this point, I had already lost my partner in my observation.
Okay, but this is at 19 seconds for the record. Would you agree that both of Mr. Jones's arms are above the counter at this point?
Yeah.
So he has not removed anything from his pockets since we were able to see him on camera?
Correct.
Okay. And then this is at 22 seconds. You can see that he's holding something. Would you agree?
Yes.
Okay. And at 25 seconds, it's clear that that is his wallet. Is that correct?
Yes, and that's the firearm right there.
That's correct. Would you agree that that is on the counter and not on this person?
That's what I said, yes.
Okay. And that in the duration of this video, as far as the camera shows so far, it has not been taken from this person placed on the counter.
As far as the camera shows.
Okay. And at this point, the audio, I think, is kicking in, but are you beginning to ask him if he has a CPL?
Correct.
Okay. And you said that he was not giving you an answer, was a yes or no?
Correct.
Okay. Still no answer as to yes or no, is that right, at 34 seconds? And you're applying, or your partner is applying handcuffs at this point?
That's me detaining.
Thank you. At 39 seconds, he's detained. And then at 42, is that your partner seizing the handgun?
Correct.
Okay.
Can you play that from the beginning, the first 50 seconds, please?
Yes. Thank you, Your Honor. Apologies about the microphone. I have no further questions for this witness. Redirect.
I have no further questions, Your Honor.
Officer, step down, thank you. Any other witnesses?
No, Your Honor.
Board defense? No, Your Honor. Okay, whenever you're ready to defense report.
Your Honor, at this time, the people would move to find over on all counts, supposed to be count one, weapons carrying concealed. As we heard from the witness, he observed a firearm upon entering the store in the right front pockets of the defendants. He then asked him if he was a CPL holder twice. Both times the defendant did not respond. When he went to pat down the defendant, he could no longer feel the firearm. And his partner recovered a firearm well within the reach of the defendant, as the witness described, about a foot or less in front of the defendant at the counter. As we saw, the defendant was the only person at the counter. At this time, he was the first person in line in the video. After the firearm was recovered, he was once again asked if he was a CPL holder. This time, the defendant once again did not provide the CPL. The immediate search was then conducted to determine whether of the firearm, determine if the defendant was a CPL holder. It showed that the defendant's CPL had been suspended and that he received verbal notice of this suspension. People believe that they have the burden of probable cause and would ask to find it.
Your Honor, the defense would object to bind over on several bases. The first being that the evidence presented today does not show that at any point Mr. Jones carried a weapon in a concealed manner. The video contradicts the officer's testimony that he witnessed a gun in Mr. Jones's pocket, and in fact supports that most likely he was withdrawing his wallet from his pocket in preparation to take. The video shows that his arms remain above the counter. His forearms are elevated above the counter in the party store for the duration of the encounter. It also shows, and the testimony shows, that neither officer established a answer from Mr. Jones regarding whether he had a CPL before they placed handcuffs on him, making it an illegal seizure under U.S. v. Floyd, which is 2021 Westlaw 2805806. That's from the Eastern District of 2021, ruling that because it is illegal to carry concealed if you have a CPL, it is a violation of Terry for someone to be detained before the officers are aware that they do not have a CPL. This is the officer's testimony agreed that he was paying at the time. If there is any connection between Mr. Jones and this weapon, which has not been established except by proximity, it would suggest open carry rather than concealed carry, which is legal in Michigan without any type of special license. I would ask that this case be dismissed because people have not met their burden regarding the factual basis of the gun was at any point concealed or belonged to Mr. Jones, rather than near him and extremely open in the public. The object he was holding was his wallet, which is another dark rectangular object. And because once a stop was conducted, it was done so in violation of the Fourth Amendment because of U.S. v. Floyd, and so the result of that seizure, regardless of the facts of the case, which are not convincing themselves, should be suppressed. So I would ask that this case be dismissed.
I was just arguing that we did only see the officer in the body worn cam entering the store, and he did testify to seeing the firearm and the defendant's the handle of the firearm sticking out of the defendant's right front pocket. And once again, asked to find over.
Okay. The court heard testimony from Officer Deshaun Perry of Detroit Police Department, who was with his partner, Officer Flannel, whose body cam he was wearing. He was in a modified uniform, green pants, black vest, with police on the vest, on routine patrol, and he said that he walked into the liquor store and observed the defendant at the counter with the handle of a black gun shooting from the defendant's pants. That he advised his partner of the gun, engaged the defendant at that point, and asked if the defendant was a CPL holder. The defendant never responded, and that Officer Perry observed the defendant turn his right side, as he stated, was pinned against the counter. And then after that, Officer Perry went to recover the gun in the pocket, and the gun was not there. And that's when he observed his partner, Officer Flannel, recover the gun on the counter, which was within 1 foot away from the defendant. And it was a black firearm. And Officer Perry then detained the defendant and verified her lien from observing the lien search that the defendant was not a CPL holder. Let's see here, the gun was placed on evidence. So the issue here with the defense counsel is Officer Perry's credibility. So before the video, I should say, when the video starts, it shows the defendant with his body turned to the right up against the counter, and it shows the defendant with a wallet in his hand and a gun on the counter within his reach. The testimony of Officer Perry before the video starts, once again stated that he saw a black handle protruding from the defendant's pants. It was the reason why he engaged the defendant after it had CPL. So the question here would be, this would be a question of fact for the trier of fact, whether or not Officer Perry's testimony is truthful before the video started. We can't see what happened before the video because the video did not start until the defendant was standing at the counter with his right side to the counter and the gun was on the counter. And based off of Officer Perry asking the defendant multiple times if CPL or no response, I do believe that people have met their probable cause verdict for the 1 count of carrying a concealed weapon. So I will have Mr. Jones bound over for an arraignment on the information for March 7th at 9 o'clock at Frank Murphy Hall. Not for you, the party. No, you're right. All right. Good morning.
Good morning.
How are you?
Good, Your Honor. I have a case that you are assigned to, but it was scheduled in front of Judge McConaughey for a bond review, and I don't see anyone picking up over there, so I was wondering if perhaps it got transferred to you.
It's for a bond redetermination hearing?
Correct.
Okay. So I do know that he's doing all of those. So let me see where he is. Is it important? Courtroom 533? Is that what you have?
I just had went on to his Zoom link over there.
Let me see.
I don't know if it's off the schedule because my client found it out, and that's why but I just don't want to miss anything.
What's your client's name?
William Welch.
WELCH?
Correct.
Let's see.
Yeah, the only thing that I saw on his screen was to log into your courtroom for landlord-tenant cases, I believe.
Okay, so he did have one scheduled at 9 o'clock today. So let's see. Okay, I'll give you the courtroom phone number. Do you have that already?
I did. I tried to call, couldn't get a hold of anyone. It's the number that's posted on the website.
Let me see. Give me one moment. Hey. Pretty good. How many are you trying? Or William Welch. Okay, so the clerk is waiting for your call. The number is 596. 3953. 3953.
Thank you very much, Your Honor.
You're welcome. Have a good day.